Okay, hi everyone. Good afternoon. This is Eileen from the Washington State Coalition Against Domestic Violence, and we are going to get started on our webinar on Child Support 101. So we'll talk about the basics about child support that domestic violence advocates need to know, and we'll be here from 1 to 3 or earlier if we're done, and I'm here with my colleague from Division of Child Support, Nancy, who we will have a lively discussion, hopefully, and we'll be ready to answer your questions as well. So we'll get started. So our agenda for today is we'll go over some brief logistics for our call with the webinar format, but then we'll dive into some terminology, and then we'll talk about child support, and we'll have lots of time for comments and questions throughout the presentation. So we'll talk about how to go ahead and ask your questions, but we're happy to stop as we're going. We don't need to wait until the end. So welcome again. Like I said, I'm Eileen from the Coalition, and I right now coordinate our prevention work, but also work on the child support side of our economic justice project along with Tracy Underwood. And so I'm always happy to be available to you for any of your child support questions. Tracy is more of our welfare person, so if you have TANF questions, but either of us are happy to talk with you about any of these issues. And we're joined by Division of Child Support Policy Expert, Nancy Copter.
Hello, everybody. And I wanted to just start out by saying how wonderful it is you do what you do. And seems lately everything I read and everything I talk to different people about is about compassion fatigue and vicarious trauma. And I was getting sort of really bummed out for a lot of stuff. And then right before I came to Eileen's office, I stopped for coffee, and I saw someone in the t-shirt that made me so happy because it said, the greatest source of energy is pride in what you're doing. And it just made me so happy. and I think that's really, I think where a lot of where the energy comes from is we're doing good stuff. And we're helping people, and you need to be proud of it and not focus totally on the downside of it, because you're doing pretty cool stuff, and you should be proud of it. So we will talk today about getting people safely through the child support system. And like Eileen said, we are always happy to get questions. I don't know if we're going to do the raised hand or speaking thing, so we'll go through that, but we're glad you're here.
Okay, great. I love that t-shirt. I hadn't seen that, but you know, I have a lot of pride just from the fact that we at the Coalition have had such a strong partnership with Economic Services and Division of Child Support for so many years, and it's just such a pleasure working in particular with Nancy, but also with all the folks over there. So we'll talk about how that partnership has sort of evolved and who you all can have access to, and they are really helpful resources for you too. So we'll continue to talk about that. But thanks for being here. Okay, so here is our logistics session. So listening, which I love this, it's like a heart in an ear. It's a little bit creepy and cool.
I just noticed the ear was in there.
It's like both things, but anyway, listening is an act of love. So the easiest thing is, which hopefully if you're hearing me, you are listening through your computer speakers, and you might have to unmute your speakers. And if that's not working, so if you're hearing me like in and out, you can select the telephone option. So it's always funny to me that we say this out loud if you're having problems you can't hear. But hopefully this is helpful for folks who can't hear but can see the screen. In terms of participating, we really do want you to participate, even though it doesn't seem like it because we've muted you all. But there is a hand-raising box, and then there's also the question box. So let's just try it. If you can hear me, if you want to raise your hands, and we'll see what that looks like.
All right, I see some.
Yes, good work, everyone. Okay, I'm going to put everybody's hands down. Okay, thanks. So I'm glad that that's working. So that's a great way, and then we can unmute you specifically, or if you'd like to type your question into the question box. And it can be a comment. It's just called a question box.
And using the question box is good, because if I'm yapping at you, then Eileen is looking at the box, and if she's the one talking, then I look at the box. So we try to sort of catch on to what you're
Yes.
asking fairly quickly.
Yes, teamwork makes the dream work. So we're on board. Okay. All right, and then this has happened to me a number of times, so we included our hot tip of if your panel that kind of allows you to see everything and raise your hand and all of that minimizes, you can just hit that arrow and it'll pop back. And then most importantly, we really are interested in what you think and what's helpful and what's not and what you'd like to know more of. So there will be an evaluation form that pops up when the webinar ends. So we wanted to hear from you on that. And then the other thing is we really want to hear about who else was sitting with you attending this webinar so that we can make sure that you get credit for participation. So the first question will ask you who was there, and you can just put all those names in there, and that's how we can keep track. And then finally, Becca, our lovely admin help person who is fantastic and is a bright, shiny unicorn, is available if you have any issues. You can email her, and she's also actually on right now just for a few more minutes to make sure that everything goes smoothly. So thanks to Becca for all her help. Okay, I think we covered that, hopefully in record time. So we're going to move on. I want to alert you all. Well, I want to say one thing. We are recording this session, so for folks who don't want me to say your name, if you write a question, just let me know that and I won't say your name. And similarly, if you want to speak without being acknowledged who it is, that's helpful too. Otherwise, we are recording it, and it will be available on our website at some point. The other thing I want to call your attention to is on the right, I think it should be on the right-hand side of your screen, you'll have a section that says handouts, and we have the PowerPoint from today as a PDF up there, along with the Terminology Stew handout, just a one-pager front and back that has all of these terms, which we won't necessarily go over right now, but I just want to let you know that I know that we have a bad habit of using jargon and acronyms. We will try to be sure to say what we mean when we do that, but feel free to call us out and ask for clarification, or to look at your handout that you can open while we're talking. The main ones that we're going to use, just to give you a preview, is DCS, which is Division of Child Support, which is part of DSHS. We'll probably use CSO, which is our version of a welfare office here in Washington, which stands for Community Services Office. I'm trying to think what else we CP, Custodial Parent, which means the person who has primary custody.
And TANF is a big one.
Thank you.
It's the abbreviation for Temporary Assistance for Needy Families. And I'm amazed. TANF has been around now for almost 20 years, and there are so many different ways to say it. And,
oh, really?
And I say it TANF, and if you say TANF, then I know what you mean, but there are people who make it a one-syllable word, TANF.
Oh, I didn't know
And then there are people who put the stress on the last signature, TANF. And it just sounds so bizarre to me. But those of you who might be a little older, the original government welfare program was AFDC, Aid to Families with Dependent Children. And then in the late 90s, they did away with AFDC and they created a new welfare program called Temporary Assistance for Needy Families. And they put the T in, the temporary, because one of the hallmarks of this program was there were going to be term limits in how long you could receive these assistance benefits. Over the years, there have been changes in who qualifies for extensions and what counts as a month and what doesn't. So you'll still hear time limit stuff, but that T is temporary. And I don't think it's, maybe part of the issue is the temporariness of TANF, but also with different economic changes, the TANF caseload that the state of Washington has is always getting smaller. And what that means from my side, from the child support side, is when you start receiving TANF, when you apply for TANF, you assign your right to support to the state, which means you've just invited the Division of Child Support into your life. We're going to talk about this in detail today. And we started working with the coalition a long time ago because for me, it's really important that even before someone goes into the welfare office, they know what's going to happen, and that child support is a necessary component of all of that, which if you think is going to be dangerous, you need to talk about. And so what we've been working on all along from then is getting as much information to families, to parents, so that they can make an informed choice about what's going to happen once they access government services, instead of just getting a nasty surprise because you didn't know what could happen. And that's why I love doing these advocate trainings, because you're the ones who work with the survivors, and the more you know, the more you can help them know. The more information we can get out is great. And I know many years ago we set up this, what I thought was a really good Q&A on the DCS internet page, in hopes that you could look at it before you went on TANF and could make some choices. As the internet and different developments came about, I found it harder and harder to locate that information on the website. And so, I started thinking, well, I've got good information, but no one can find it. So what are we doing there? And so sort of at the end of this, we're going to give you contact information for me and contact information for Eileen. But as you go through dealing with survivors, looking at how they interact with the government, if you see something that just doesn't make sense or doesn't work for getting information the way you think the people you work with need it, I would love to hear that, because usually what happens is we set up the system in a way that we think works, and then the gremlins go to work on it, and who knows where it is now. But I don't have any pride of how it looks now is the way it's going to be. I need to know what works best for the people you work with.
That's great. So just as a reminder, we'll have resources at the end, and we actually have a link to the page, at least our own version of it on our website, so we at least can find that. And then for folks who didn't hear, we do have the handouts, so the Terminology Stew handout, one-pager, and the PowerPoint for this webinar are also available in your handouts section on your panel. So hopefully you can find that. If you can't, feel free to send a note, and we'll help you problem solve that. Okay. Okay, so one more thing about language. I'm sure many of you have heard me say this before, but in terms of gender, we often use gendered language, and some of that is intentional and some of it is unintentional. So I just want to acknowledge that, of course, either the mother or the father can be a custodial parent, non-custodial parent, or a victim and survivor, and we know that. And that said, the majority of custodial parents in the DCS caseload, in the child support caseload, are women, and the majority of domestic violence survivors are women. So often that information is reflected in how we talk about different scenarios and different stories. That said, I do not want to minimize the impact of abuse that folks that are in same-sex relationships experience, or folks that are in relationships where the mother or the woman is the abuser. I want to acknowledge that certainly happens, and my language is not meant to minimize that. But the reality is I often have a crutch, which is to rely on the stories that I know, which are more often than not the mom being the custodial parent and the survivor.
When we first started doing these trainings, we didn't have this warning up here, and we would get people, oh, obviously you don't believe that a man can be a victim, or what about same-sex people? And so Eileen and I looked at statistics, and in the DCS caseload, I think at that time when we looked at custodial parents, I think there were 87.5% of the custodial parents in our caseload were female. I just looked at it. I happened to be looking at statistics for somebody else's presentation, and the numbers have changed. Now it's 87.5%. So it's pretty steady along there. And so whenever you hear mother or father, this is just like the changes that have been made in the statutes by the legislature lately, when they made changes to the Uniform Parentage Act, there's a provision that says where you see mother, you can assume it means father, or just call it parent. And so we have to call them something to indicate their role, because in a DCS case, my role as the custodial parent is different from when I'm the non-custodial parent. But since, I could be anything, I could be both. I could be a domestic violence perpetrator, or I could be a survivor. It all depends on the context. So we're not dissing anybody. We're just, I guess, using our custom lingo because of the stats.
Yeah. Okay, great. Okay, so why on earth is the Domestic Violence Coalition giving a webinar on child support? So we think that there's lots of reasons that it's important for advocates to know about child support. So here are just a few of them. What we know from the research is that child support can be really helpful, and that when there's a steady income, even when it's small, so even if the support order is for a small amount, families are less likely to access public benefits. And the key word in that stat is the steady income, so it had to be reliable for that to make a difference. But even if it was a reliable amount of small amount of money, it made an important it helped folks kind of get above the threshold for accessing public benefits. And then for low-income folks, child support can be a pretty big proportion of what they're getting each month, and so it just makes a real difference. So that, is from the research and from what we know as well. We also know that with the child support order, a non-custodial parent can be required to provide health insurance coverage and contribute to uninsured medical expenses, so something that otherwise just wouldn't be included. And then additionally, this is something that I learned after doing this work, was that with a child support order, a non-custodial parent can be made to contribute to somebody's college education. And so this can happen only with a court order for support, so not something that's the administrative order, and Nancy will talk about the difference between those. But that's just something to keep in mind, especially for folks who have sort of long-term thinking about, at this point, I'm not interested in it, but it's good to know that in the future, if I wanted to have some help paying for post-secondary education, I could. So that's just something to keep in mind, especially when folks are, like, oh, writing, I don't want to deal with it, writing them off. And just, these are the options. It's absolutely your decision, and know that with an order, you could require this.
And post-secondary education means after high school education, because there's elementary and high school, and then a lot of people call high school secondary school. But post-secondary ed can be not just college education, but also vocational education. So a lot of parents want their kids to get some sort of education after 12th grade. And there's a lot of discussion in the state of Washington, actually around the country, about this topic, and there has been for years and years, because if my husband and I are together and married and raising our kids, no one can make me contribute to my kids' college expenses or vocational school. But if we are divorced and subject to a child support order, the court can say, Nancy, you have to pay toward this. And occasionally we will see bills in the legislature that try to do away with post-secondary educational support, but it hasn't happened yet. And the important thing to remember, DCS can establish what's called an administrative support order, but you only can get post-secondary support if you are in the courts.
Okay. So here's the dilemma for folks. So we've acknowledged that it can be really helpful, and it can add a considerable amount to a survivor's monthly income. We also know, this is basically the real answer for why child support is important, that we know that access to money and resources help survivors stay safe, get safe, become safe. So we know that, but we also know that going after support can actually be a huge safety risk for survivors. And so people really have to weigh those risks themselves. As advocates, I think we're in a really good position to sort of lay out the process and help people figure out what makes the most sense for them. So that's really ultimately why we like to talk about this. So the bottom line, for us as advocates is to provide as much information as we can about kind of the good, the bad, and the ugly of child support so that the survivor can make their own decisions and choose what makes sense for them.
And what I found over the years dealing with this is I've talked to people in the community services division, the welfare side, and also on the child support side. And there's sort of, I don't know if it's a I know better and how to take care of you type of attitude or something, but every now and then I hear from someone who says, Nancy, I really think this person should claim good cause, but they won't. And to which I say, yippee, because what I'm hoping is that means that the survivor has gotten enough information to decide this is the right path for my family. Because if you claim good cause, yes, we won't get involved and you know, it doesn't further inflame the perpetrator. But a lot of survivors say things like, no, I want that person to support his or her children. And if that person supports his or her children, then I no longer have to be on welfare. And it really is a decision that the survivor should make. I shouldn't be making that decision for the survivor. And again, so that's why we're here doing this, is give them the information so they know what's right for them.
Yeah, and we'll talk more about what that process looks like, but that's definitely the bottom line. So moving forward, in terms of what DCS can do, so like I said earlier, DCS, Division of Child Support, is part of DSHS, and I'll let Nancy describe what you do since you obviously are the expert on
Well,
that.
thank you. So the reason we were created, and the Division of Child Support is a creature of statute, and what that means is the courts have this sort of general jurisdiction, and they can do pretty much anything that comes before them. The Division of Child Support was created to be the child support registry, to process payments, to provide establishment and enforcement services, but our powers are limited. So if you come in to the system with an existing child support order, I can enforce it. If you don't have an order, chances are I can establish an administrative child support order, but there may be a question of parentage. Do I have a legal basis on which to hang the administrative order? And we can also get referrals to establish paternity or parentage. And what that means is if we can do something administratively, we'll do it. If we need to go to court, we have contracts with the prosecutors all across the state and every county, and we can ask them to bring court actions. Sometimes we may have to refer a case to another state, but there are a lot of things that we can do for a parent, and even there are non-custodial parents who will apply for services from us sometimes. There are a few things we can't do. An administrative child support order just sets the money amount. It would say, Nancy, you have to pay the father of your children X dollars a month. Oh, and here's your medical support obligation. We can't establish spousal maintenance. That's something that's within the power of the court. Spousal maintenance is what the legislature in Washington calls alimony. And like we said before, administratively, we cannot establish a post-secondary support obligation, although we could enforce it. And we cannot enter a parenting plan. However, you may have heard that the most recent change in federal law regarding child support happened in 2014, in September, towards the end of 2014. And there was expressed a sense of Congress. So it wasn't an order, it was just, boy, it would be really cool, which is not something you see in federal law a lot. And they didn't use those exact words, but that's what they meant. That wouldn't it be wonderful if, when you establish an administrative child support order, you can assist the parents in entering a parenting plan. And unfortunately, the Congress at that time did not provide any funding to take care of those services. And, you know, the different states have talked about what this could look like. If it's a state there are some states who only do court proceedings to establish child support, so it would probably be easier for them to come up with a parenting plan. Should we have the funding to do this, probably what would happen in Washington would be maybe we would contract with like the Dispute Resolution Center or some provider who could help parents work on a parenting plan. We don't have any ideas on how we could do that, and since it's not officially required yet by federal law, I don't see the legislature really funding it for us. But we are fully aware, mostly because I sit there saying, what about survivors? If we ever came up with a program like this, there would of course be provisions for how do you deal with families where violence is involved, because you can't just dump everybody into the same program and expect everybody to, treating everybody the same way and come up with a just result. So if we do get involved in some sort of helping people get parenting plans, there would of course be provisions dealing with what do you do when I've got violence involved. And should we get into something like that, we would of course work with the coalition and let you guys know what's going on. So don't think we can do it now, but there's a possibility in the future we might get there. But essentially right now in the state of Washington, if you want a parenting plan, if you want spousal maintenance or alimony, if you want a post-secondary support obligation, you need to go to court. If it's just, I need a child support order, we can do that in DCS.
Great. And just so in terms of what I've learned over the years is that different states do it really differently, right? There's as many different ways to do it as there are states. And so, sometimes these things are linked in other states. And so survivors who are coming to us from other places may have preconceived notions that actually don't end up being true. And so it's just helpful to sort of know that there are lots of different ways to handle it. But here in Washington State, we have a pretty clear distinction between the court orders and child support. So we'll, of course, talk more about that as well. So when does DCS get involved in your case? I feel like in some ways this is, the first bullet is what we talked about the most, and it's, I think, just one of the things that all advocates should know, even if you don't really know anything else about child support. I often wish there were flashing lights at at the welfare office that just said this, but that anytime a child goes on TANF, so gets welfare or temporary assistance to needy families, that automatically triggers a child support case. Now, like Nancy said, of course, there are ways that we call it good cause, but there are ways that you don't have to do it, but in terms of the process, it really does automatically open one. And this is really from the roots of lots of different things, but really trying to get folks to there was a big thing when TANF passed around. I don't know if you remember, those of you who are old enough, around Clinton and the deadbeat dads and all of that, that really this is, I think, a big piece of that. But it has roots that are deeper as well. But ultimately, if somebody gets on TANF, the state is hoping to recoup some of the costs by virtue of getting child support that then reimburses the state.
And that's why, the child support program pretty much, the child support program that exists today came about in order to help reimburse the state and federal government for people receiving public assistance, both AFDC and TANF. And that's why, there are, occasionally you hear about a movement to say, if you don't give us the name of the father, you can't receive benefits. And because ultimately what it is aimed at, yeah, the taxpayers will be happy to provide a little support, but we want to go after the parent, and so which is where that comes from. And like Eileen says, when someone is talking to you about, I think I want to apply for public assistance, cash assistance, TANF, something should go off in your head, and you know that this is going to lead to a case. Is this going to be dangerous for this person? What can we do?
Yeah. And so we'll talk about what that looks like and how to do that. But it's always more helpful to have that knowledge before before TANF gets opened. If the best practice can be that going in that you want to get good cause. And again, we'll talk about that exactly how that process works. But yeah, if you can just remember that, that's the alarm bell you want. There's other ways that DCS gets involved, and these are much less common for us. But in terms of foster care, you may have heard about it that way. This one is a very specific one. The court order requires payment through, I like to say this acronym, WSCADV, which is the Washington State Support Registry, but that's a very specific thing. Tell us when that happens. I can't remember.
State law, RCW 26.23.050 says that every child support order, whether court order or administrative order, shall provide for child support payments paid through the Washington State Support Registry, WSCADV, which is my second favorite acronym after WSCADV.
It just rolls off the tongue in the same way, doesn't it?
And so you go from a presumption that you're going to pay through the registry, and if the parties can convince the court or the administrative law judge that, number one, they can get along, and number two, they don't need to be forced to do it, then they can provide for payment either directly to the other parent or through some other way. But the assumption is, the presumption under law is you're going to pay through the registry.
Great. And that can be really helpful. We'll talk about why, but in terms of having a record and those kinds of things. So the other ways is that a custodial or a non-custodial parent asks for services. What percentage of your caseload is this right now?
All I know is it's a really small percent. I have not checked it, but it's sort of, I think it goes back to the idea of one of the roles of the Washington State Support Registry is to provide a record of payments. And I have seen non-custodial parent applications in different circumstances. The most frequent I've seen is a man who wants to be established as the father of a child, and the mother wouldn't agree to sign a paternity acknowledgement. And so he needs the court to convince the mother to undergo genetic testing and establish parenting, when usually it's the other way around. The court is roping in the dad for this. And I have also seen non-custodial parents who pay the custodial parent cash or even checks, but then when it happens that mom goes on TANF, or something happens that the state gets involved, the custodial parent says, no, I never got anything. And so non-custodial parents will sometimes apply for our services so that they have the record of payment.
Yeah. And then, of course, when somebody's coming from out of state and they ask for services. So, okay, so we'll talk about, mostly we'll talk about TANF, but the other ones will come up. So this is our full meal deal slide, which we love, the milkshake and fries and burger. It's always good to do this after lunch. But getting involved in your case in terms of DCS, well, actually, I'll let you do this slide too. Go ahead.
Some states will have different ways to handle their cases where family violence is involved, and they'll provide some kind of limited service or help the custodial parent pick and choose and say, well, I think he'll be okay if you take his wages, but if you make him pay medical insurance, he's going to go ballistic. Or I don't want him to have to pay medical insurance because then he'll find out that the kid's in counseling or something like that. There are other states that have like a red light, yellow light, green light system where they would contact the custodial parent and say, we're about to take this step. Do you think this would be dangerous? And in Washington, for a number of reasons, we can't provide that individual attention, mainly because the last time I looked, we have approximately 380,000 open cases. We just don't have the resources to provide that fine of case management. And so essentially what you get is a full enforcement case or nothing. And so if I am a non-assistance person, which means I'm not receiving any cash public assistance. My choices for DCS is I apply for services and I get everything DCS does. If I don't want DCS to do that, I have to close my case. If I come in as a TANF applicant, then I can either have a full support enforcement case or I can request good cause. And we'll talk later about there are two levels of good cause. Good cause level A means it's just too dangerous to do anything, which means DCS does not work a case. Or good cause level B, where DCS works the case but does not require the custodial parent to participate. And we'll look at that. So you may, if you have experience from other states, know about these other levels of service, but that's not what happens in Washington.
Yeah, that's all or nothing.
Yeah, all or nothing.
Okay, great. So this is my public service announcement that I like to make, which is I think a lot of times survivors and advocates and myself relied on the fact that, well, you know, if somebody's working under the table, it's not really an issue. They're not going to find the non-custodial parent. I don't actually have to worry. And I just want to reassure you or caution you, I'm not sure which one it is, that DCS is actually really good at finding people. So there are lots of ways that DCS, they're sort of like little detectives, and they love it. I mean, it's so funny. Whenever I'm in a room of support enforcement officers, they are so happy when they get to track somebody down and find them. So they use really creative ways to get an NCP to pay. They can actually suspend a license. They can take property. They can prevent you from getting a hunting license. So there's lots of ways that they can sort of infiltrate and find out. So it's not a great safety strategy to assume that DCS won't be able to find folks. So that is something that if you feel like a survivor is relying on, it just might be good to have a little reality check around, especially nowadays, with just that everything is so connected, and they have their fingers in everything. So.
Right, and I've worked for child support for 26 years. We did have computers back when I started. They were pretty basic, but I'm 58 years old. I remember when I was young, talking to friends whose parents were divorced, and one of the parents would just totally disappear. Well, in the 60s and 70s, there was no way to find them. And that's when the child support program started, was in the 70s. And so you may hear, or people have their family lore, that, oh, he disappeared and no one ever got a dime from him. But I don't really think the average person can disappear anymore. Yeah. There's going to be some record of you somewhere. And it's not just state government, it's the federal government. There's international cooperation, not everywhere, but a heck of a lot of governments saying we want parents to support their children. So there are a lot of ways that we can find people. And I don't think it's safe anymore to just assume no one will ever find him, so I don't have to worry about the child support case. I would say, and I'm not saying we find everybody, but we find almost everybody. Let's put it that way.
Great. Okay, I'm going to pause here. I see Grace, you have your hand, Grace Bell, I see that you have your hand raised. So I'm going to unmute you. And if it's a mistake, you can just let me know. But if you meant to raise your hand and you have a question, I'm going to unmute you. Okay, Grace. Grace, if you can hear us and maybe you don't, it's possible you don't have a mic on your computer. So if you want to instead write a question or a comment, we can handle it that way. So I'm going to give you one more second. Oh, she's writing a question. Okay, perfect. Oh, she does. Okay, no worries. All right, we'll see, but you can tell that it worked. So I'm going to lower your hand. But this is a good place to pause if anybody else has any questions before we really get into the nitty-gritty. So if you have any big picture questions, it's a good time to pause.
And also, while we're talking about this, feel free to raise your hand or ask a question now. But child support can last a very long time. And if you entered a child support order in Washington today, that order would be collectible until 10 years after the 18th birthday of the youngest child named on the order. And so it's not just, oh, I can wait till the kids are 18 and I don't have to worry anymore.
So I see Grace's question, and it says, I see a lot of moms who are afraid to get child support because they are worried that the other parent will get custody of their child. How do you talk to a client about this? Or that the other parent will have some sort of power over their child. So I think those are, I think those are fairly common concerns. In our state, you know, it is separate, as Nancy mentioned. Having a child support order does not necessarily mean that there's a parenting plan. Judges still want to defer to a parenting plan, right? They really want people to get one of those before they make decisions about restraining orders or protection orders and things like that. So I think the reality is that they're separate. And that said, there is also the reality that, you know, visitation is separate from child support, and but people feel entitled to visitation often if they are paying child support. And so I think I think for me it's worth talking with the survivor about the reality of what she thinks visitation will look like or should look like, or what she's nervous about, and really unpacking that and finding out what's worth it to her, right? Is it, you know, is going on TANF? I mean, I would imagine people who qualify for TANF need TANF, right? I mean, they're very low income and they need the money, and is good cause and not going after child support a good solution in that case. It doesn't mean that those issues will go away, right? But if she feels like alerting, I'm trying to think of how to say this, if she feels like it'll be dangerous for her to alert the other party that they're on TANF, and that's one thing, but not wanting visitation is not a good enough reason to get good cause. So we'll talk about that specifically, but I can see Nancy has a thought.
And under the law, you have a responsibility to support your child. You also have the right to parent your child, and they're not dependent upon one another. By that I mean, if I pay child support, the court could, in appropriate circumstances, say, Nancy, you cannot see your children. If I am the perpetrator, if I have committed domestic violence, not just against the other parent, but against the kids, or I've done it against the parent and I've done it in front of the kids. So there are reasons for the court to limit my right to see the kids. Just because I can't see the kids doesn't mean I don't have to pay child support. And, you know, you can see this kind of argument. It's another way of trying to control somebody. If you make me pay child support, I will take the children away. That's not just something that happens with people on TANF. It's not something that happens only when there's physical abuse. It's a parental negotiating tool that is a pain in the ass, and you know, people are like that. But the courts, when they establish residential schedules or parenting plans, don't like to think of it as a fight for control. They look at what is in the best interest of the child, and they also will look at, are the parents trying to set the schedule of where the child is in order to get somebody out of paying child support. And it's a kind of funny area of law right now. An awful lot of people are saying, well, we want a 50-50 parenting plan. That means the kids live with mom 50% of the time. They live with dad 50% of the time. And then the argument that you hear is, we share the child equally, therefore neither one should pay. But these people are not taking a look at another part of it, which is, who makes more money? And so if I have my state job and I have a good salary, the father of my children for some reason can't work and he had to go on welfare. If I go to the court and I say, well, Your Honor, we have the kids 50-50, so I shouldn't have to pay anything, the court is going to laugh at me. because I make a hell of a lot more money than someone on welfare. If, however, not that I would do this, but let's assume I have children with someone I work with, so we have exactly the same salary. If we have the children on an exact split, then maybe we wouldn't pay child support because our income is equal. So it's not just how much time the kid is with each parent, but how much each parent makes. And it is, I realize for a lot of survivors of domestic violence, it is a power struggle. And it's something that we can't really help you deal with through the Division of Child Support. We can refer you to different kinds of legal services, but it's a very hard question for a lot of people, let's put it that way. And if we're looking at the issue of good cause and whether I should apply for services from DCS, that is a factor I need to consider. It's unfair, but it's a factor I have to consider.
Yeah. And I think the reality is that people do use the fact that they pay child support as an excuse to get involved and to wreak havoc. And so I think that the survivor is going to know best of what the likelihood of that is and what it'll mean. And so, and we'll talk more about that with good cause. But it is, I mean, it is a concern.
And then in the context of healthy child development, it is best for the kid to be involved with both parents as long as neither parent is toxic. And you know, when you're working in the DV arena, at least one of the parents does have a toxic effect on the family.
Yeah, right.
And so it's trying to balance what's best for the kids.
Yeah. So hopefully that helps, Grace, and then we can talk more about it as we continue. So this is sort of what we were just, I mean, this perfect segue, that if you're worried about a bad reaction to child support, if you're not on TANF, so if you've decided, I want some help, let's have a record, let's make sure it's really, you know, above board, you get child support help, and then you realize, it's not really working out. If you're not on TANF, you can actually just close the case. It's no problem. You can call up child support and say, I'm out.
And then we ask you to put it in writing.
Yeah.
And this also applies if you were on TANF and you are no longer on TANF. You can close the non-assistance portion of the case.
Sorry, I'm just seeing that we have a question from Sandy that says, can the mom of the kids who happens to be married still file for child support? So I'm assuming it's a mom married to someone else.
Well, how I'm reading Sandy's question is, if mom and dad are married but not living together, can mom apply for child support services against dad? Yes. If mom and husband are married and dad is somebody else, mom can apply for child support services. And there are legal hoops to be jumped through because if a child is born to a married couple, the other spouse is presumed to be the parent if the child is born during the marriage or within 300 days after the end of the marriage. And this is called the marital presumption. And so you wouldn't have to establish the husband's parentage of that child. It's just going to be presumed it's that way. And then you could get into a situation where mom is married and then has a child with bio dad who is somebody else. And so you've got the husband is presumed to be the father. Mom and bio dad could go to court. You know, she could apply for services and ask DCS to establish paternity, you know, say bio dad is the father, not the husband. Mom and the bio dad could sign a paternity acknowledgement. The difference that comes in when mom is married to someone else is that husband has to sign a form that's called the denial of paternity. And so if we just have two people not married to anybody, they can sign a paternity acknowledgement, the mom and the biological father. If mom happens to be married, then what you need to establish the parentage of the child is mom and bio dad sign the acknowledgement, and husband has to sign the denial. And then the establishment of who the parent of that child is not complete until you have both the acknowledgement and the denial signed by husband. And there's been in the last several years bills in the legislature. The concept is called paternity fraud, and that's not always what it is. A lot of times it's a big fat mistake, but it's under current law, and we have Chapter 2626 RCW is called the Uniform Parentage Act. And there are provisions in that law that if you have specific questions, I'll be happy to talk to you later. But essentially, when does the law presume who the father is? How do you establish paternity? And then what's happened in the last few years, there have been bills, people testifying in the legislature about, you know, she told me I was the father, so I signed the paternity acknowledgement, but now the child is 12 and I found out my best friend is the father, but the law says you can only, you know, there's just 2 years to challenge or 4 years to challenge. And so there's a lot of interest in the legislature on making sure you have the actual biological dad. And then there's case law in the state of Washington saying, well, even if he's not the biological dad, but he lived with the kid for a lot of time and the kid calls him dad, can we make him still be the father? Because you're just going to screw the kid up if you say, well, no, actually not dad. So it's a complicated thing, and what I've learned in the time that, well, all the time I've been alive, but more since the time I've been a lawyer, is people will come up with the most bizarre ways to screw up their lives, and you think you've figured out everything, and then someone will tell you another fact pattern that you couldn't even have imagined. But anyway, back to this.
The answer really is yes. It sounds like
Yeah.
really in all cases, and that it just takes a different level of kind of commitment in court order or
right, different
whatever,
actions going on. And with the time limits now under the Uniform Parentage Act, what I could see being a problem would be if the child is little, like under 2, and there's never been a court order or administrative order saying husband has to pay child support, it's relatively easy to ask DCS to refer the case for a court proceeding for paternity. If it's more than 2 to 4 years, if other facts have happened, it gets more complicated.
Okay.
So you may come up with a fact pattern where it's essentially, I'm sorry, the law says you can't go anywhere. And then, but it's always worth asking. Yeah, I suppose that's my answer there.
Okay. Okay, so now we're going to move on to kind of like the meat, really, which I added this picture. I don't know if you saw it, Mr. Yuck.
Yes.
Which made me chuckle. So this is really, I think, the more common scenario for you all is that somebody's worried who's actually on TANF. So again, this is the key. The best practice, like if we can figure out how to do this more times than not, I think we'll be in much better shape. But if a custodial parent can claim good cause on application, so at the time of application, to not cooperate with DCS. And so, you know, what we encourage folks is to, if you can really talk with the survivor before they go in, to not wait for this. CSD stands for Community Services Division. Those are the folks that run the CSO, the Community Services Office, the Welfare Office. So don't wait for that worker to ask it up, bring it up. So say, you know, hey, I know that when I apply for this, it opens a child support case. I'm really worried about that. Can I apply for good cause? And we'll give you the form number also coming up that you can really, you know, send them in knowing all the details. But if that doesn't happen, good cause can be claimed at any time when somebody's on TANF, even after the TANF grant is closed. And good cause is actually determined by staff at the welfare office. But that said, it really has changed over the years to be much more driven by the survivor. And then DCS will wait for the decision before they take any action.
And this is also something that has changed due to us being more computerized and, you know, the technical stuff happening. When I first started working for the Division of Child Support, we were called the Office of Support Enforcement, and we would get paper referrals on TANF cases. So, or excuse me, it was AFDC then. So the survivor would go into the welfare office, fill out an application, and then the welfare office would send that paper to the support office. And so it was a matter, several days would go by. We didn't really get a lot of information really soon, but today, if somebody applies for TANF, either online or in the office or whatever, overnight, the TANF computer is going to talk to the child support computer, and I'm going to have a referral. And we have a federal requirement that we open the case and start working it within a certain number of days. So the automated actions just help us figure things out and get things going faster. If the survivor has claimed good cause not to cooperate with DCS at the time of application, that electronic referral is going to come over with a flag saying good cause claimed. So what happens is essentially we set the case up on our computer system and then we sit it to wait for a decision. If the case comes over not flagged, then we start working it, and one of the first things that happens is there are notices that go out to both parents. Hi there, you have a child support case with the Division of Child Support. Here's your case number. And so I can't stop that unless the case is flagged for good cause. So it's very early on that the other parent's going to find out. One other thing, I think it's getting better, but if you can remember to educate people that it's either something like child support good cause not to cooperate with DCS, because good cause means different things to different people. And even within the welfare system, even when you're talking family violence, there are two meanings for good cause. One is the child support good cause, which stops us from working the case. The other is under the Family Violence Amendment. You may have heard about it, Wellstone-Murray Act, I think was what it was. And this is if I apply for TANF as part of my Work First plan. There are certain things I have to do in order to remain qualified to receive Work First, except if I can show family violence, that may give me good cause to be excused from certain requirements of the Work First program. And don't ask me why, but there have been CSD workers who would hear good cause and immediately put that person into the Family Violence Amendment for Work First requirements, but not also make the connection that, oh, this means good cause not to cooperate with DCS. And ultimately speaking, yes, the good cause Work First requirements is important, but the most important thing is good cause not to cooperate with DCS, because that stops us from opening the case and proceeding with it. We've talked about this a lot with CSD, and I know they've done a lot of information for their workers, but I think the best thing is as soon as your survivor is talking to anyone, applying or discussing, the magic words, I hate to require magic words, but child support good cause not to cooperate with DCS. Make sure you connect good cause and DCS.
Right.
And one of the things that I like about the good cause process is if the custodial parent survivor does not say immediately at the time of application, I want to claim good cause not to cooperate with child support, you can still claim good cause at any time during the time you're receiving TANF. And so, if just things come to a head, you can do that. And I have had success with, even when someone has terminated public assistance, and then now is the time, maybe this is when the perpetrator got out of prison or moved to your state, who knows. All of a sudden, the perpetrator is causing problems as the non-custodial parent. It's not something that's really intuitive. for a lot of people, but we can ask the Community Services Division to go back to the TANF time period and evaluate the survivor's good cause claim, sort of on a retroactive basis. And so if I can get them to make that retroactive good cause finding, then we can get that protection even while there's no TANF paid. And what I've found is if we've been doing it enough through DCS that I think most people know about it, but if you are talking to a support enforcement officer or your client says, I asked my worker and they said they didn't know about that, that would be a great time to call Eileen or Tracy or to contact me, because I work in a building where I'm on the 3rd floor and on the 1st floor is CSD headquarters, so I can just go down and bug someone and they will educate, reach out and educate their worker. So it's not an automatic, yeah, everybody knows about it, but it's something we can do.
Yeah.
So sort of keep that in your back pocket.
Yeah. So somebody asked, how this works, and so this next slide sort of kind of walks you through. And so I think if I had my druthers, survivors would know all of this and would walk in asking for what they need, so that we don't leave any room for error. So, if you happen as advocates to meet with somebody before they're on TANF, I think it's always great to give them this information. So the most helpful thing to say is, I like good cause for non-cooperation with child support, and I'd like to fill out the form 18334. This form has been around forever. We got the title changed a few years ago because it used to say how you must cooperate with child support, which was like exactly the opposite of what we were doing. So it really talks about your options. And the key is that survivors who want good cause have to state their fears and concerns about why getting child support, what child support would do. So again, like I mentioned earlier, it's not enough to say, well, I just don't want to deal with him. He's, a pain, or I don't want to have conversations about my decision making with him, which I've got to tell you is totally valid. But it's not enough of a reason to not get child support. So it does have to sort of rise to the level of fears and concerns, and then they sign it. And I think I have another slide about that. Then CSD does take them at their word. There's no, quote unquote proof required in terms of having medical records or police reports or anything like that. And we'll talk about the process between A and B. So that's something just in terms of if you can, give folks the actual name of the form, which is 18334, that can help a lot and can also clear up some of that miscommunication that sometimes happens around which good cause people are asking for.
And I just want to say, without the work of the coalition, we would not have anywhere near the system we have now. When I first started working in headquarters, which was about 20 years ago, there was no accepted regular practice that the workers in the CSD would have to go through. And there was nowhere on the application where you could say, I have fears about my safety. And I don't know how many of you have seen the current application for benefits. Maybe that's something we could put in the handouts. I can get you one. But there's a little checkbox somewhere on the second page or something that says, there's violence in my home, or something about that helpful. I can't tell you exactly what it says. And so it's what I would like to see, and what I always ask for when I'm in these meetings and they're tired of seeing me, is I would like a really big box somewhere on the first page of the TANF application that says, I have fears that trying to get child support will endanger me or the children in my household. I want to claim good cause, because that is the meat of it. And so on your application, there's that one little box that you can check. Then there's another form that they're supposed to give you in your packet. And in your interview for TANF, again, I've heard people who they would apply for TANF and someone would say, oh, you don't look like the kind of person who'd be a victim of domestic violence, are you? Or, just something not really making you want to explain. And they now have a script, questions they're supposed to ask. And I think part of what the advocate's role is to get someone comfortable enough to know that she needs to say something, even if they don't ask. And you don't have to give me your entire story. It's just, I am interested in good cause for not cooperating with child support because I think it would be dangerous. And it's harm to the custodian or the children is the important part. There are also some other reasons why good cause would be granted if the child was conceived through rape or incest. There's also a reason for good cause that adoption proceedings are in process or something. It's a funny thing. But again, I don't care what all the background facts are. At some time, you're going to need to say why I'm afraid of this person. But getting it out at the very first time you can, I'm afraid something will happen. And one of the questions that came up is, why can't we just assume that it's going to be dangerous for everybody and let people opt into collection as opposed to opt out? And if you look at the numbers, again, I don't have good historical numbers because for a long time, CSD didn't keep track. Because I remember when I first started working on this issue with the coalition, we would ask questions like, well, how many people ask for good cause each month? They couldn't tell us. How many people are granted good cause? Well, they couldn't tell us. How many people ask for a good cause in Spokane as opposed to in Wenatchee? Well, we don't know. And it's only within the last couple of years that it has become mandatory that they track good cause claims through one of their computer systems. And so if you look at the percentage of people who apply for TANF, or the number of people who apply for TANF, the good cause either claimed or granted is a really small percentage. And when you work in government, you're looking at what's the easiest way to get things processed with less time and all of that. And since the majority of people don't claim good cause, I guess that's why we make you opt out or opt into good cause. And I know I've, over the years, talked to people working in the welfare system why there are things that I need from the child support side to work my case that they don't always get at the first time of application. And they look at me and they say, well, Nancy, we have so many seconds to process an application. And our priority is getting the benefits started.
Which I appreciate.
Yeah,
which is really
great.
Good.
Which is great. But their priority is not getting me the information I need to go after the non-custodial parent. So, yeah, in an ideal world, we would spend more time with this.
And I think the other thing that's just important to remember is really the core components of TANF, one of which was to increase two parents supporting their children. Another little known fact is that it also is supposed to decrease out of wedlock pregnancy, which is very interesting. So that's another day. But so anyways, I think that's why. I think that's a really valid question, and the reality is that's not the system that we have, and this is the best that we've been able to get so far. I yearn for lots of changes, or in the next coming years, that maybe is more of a specific. Again, I'm still waiting for the red flashing lights, but just something that does more of a proactive.
But when Eileen and I rule the world, it'll be different.
Yeah, it's going to be amazing. Just wait. So here is the specifics of good cause. So once you've asked for good cause, there's two levels. There's level A, which I've sort of symbolized. If you think of it, Nancy mentioned earlier the kind of red, yellow, green. If you think of it as like go, stop and go. So good cause level A is a stop. So the DCS case is closed immediately. Here's the little thing that I'll just say again to really encourage. If you're working with folks who are not yet on TANF, if you can get people to get good cause upon application, then that case isn't even opened, which is delightful.
Well, I have to say, it's theoretically opened in that a case is created in our computer system because that's required. But we will not take any action on it.
That's what I should say, yes. So, and so that means that no debt will accrue. So that's handy. So the DCS case is closed immediately. They won't reopen unless somebody withdraws the good cause, or then they come back, however later when they're not on assistance and they apply for services. What that gets in terms of protections for the custodial parent is an automatic denial of if the NCP, the non-custodial parent, requests their address. And then if the NCP says, well, hey, I still want services, they'll actually be denied.
And what we do when we deny the non-custodial parent's application is we say, sorry, we're not going to open a case for you. And we do say, because we've closed the case based on a finding of good cause level A. We don't say, because she says you did this and you did that. All we say is closed because of good cause level A. And every now and then we'll hear someone will demand all the details, and we just say, no, we're not telling you. So we're not going to open the case, but all they know is we closed it because of a finding.
Okay, great. And then in terms of B, I have green, but it's really like green with caveats. So DCS does continue to work the case. They do let the custodial parent know what's happening in terms of that they're going after support, but the custodial parent does not have to participate, and they can't actually require it. And so what that means is that they can't be dinged on their work first participation on any of that stuff for not cooperating. So it's nice when it makes sense for somebody to sort of not be involved because that, the non-custodial parent is sort of all up in their business, and they would know if they were involved. They could say, I'm not involved. The state is doing this without me. But they still are able to get that child support established. And because our hope is that then when people go off of TANF, that child support will continue to come in and be a big proportion of their income and will actually help them with their economic plan.
And one of the big things about this that I've heard from survivors is good cause level B. They don't have to do anything. They don't have to help us. And a lot of times the perpetrator will not feel the need to work out his frustrations on the custodial parent because she says, I'm not helping them. They are doing this on their own because I needed to get TANF to support your children. And one thing we didn't talk about, but I'm hoping you know, when you go on TANF, you are required to cooperate with the Division of Child Support in establishing and enforcing child support. And so let's just assume you had no reason to claim good cause, your case is open. So you have to give us information about the non-custodial parent. You have to show up at administrative hearings. You have to answer questions that we have for you, asking questions about the non-custodial parent. If paternity is not established, you have to bring the child in for genetic testing. You have to participate in the court proceedings. And what happens if you don't? Then the Division of Child Support notifies the Community Services Division, the welfare office, that you are not cooperating, and they will take 25% of your grant. So non-cooperation is a big hit. And the way you get it back is you cooperate with DCS or convince us that we're asking for information you just don't have. Mm-hmm. But 25% of your grant is a big number.
Yeah.
And that's what it's all. Number one, is this going to be dangerous? But number two also is, if I don't go into this good cause protection and for some reason I think I can't help, then we've got that ding on the grant. And so that's,
yeah,
there's safety, and then there's the balance of the
exactly.
Not cooperating.
Right. The other nice thing with good cause level B is that it comes with the same protections that level A comes in terms of the denial of the request for address and other things. We're going to talk about pass-through another time coming up, but the if pass-through comes back, which again we'll mention later, good cause level B is nice in that regard because it enables people to reap the benefits of that. So just remember good cause level B when we get to pass-through. So what happens when TANF closes? So if TANF grant closes before a good cause determination, CSD will still have to make a determination and they'll have to enter it, and then DCS will wait to see what happens. So that's, that is rare, again, that happens, but it's just good to know that if somebody kind of got freaked out by the process and just walked away from TANF and thought that everything would be done, it won't be. So it's important to remind folks that CSD still will make that determination of good cause or not. So if there is a denial, which again, I think it's less common now because we've sort of put the survivors in the driver's seat in a different way, but the denial can actually, sometimes it's misused and it's really a withdrawal. So there is, anyway, there's a 90-day appeal period. So if somebody gets denied good cause because maybe they didn't say in their statement their fears, they just said, I don't want him to have custody, that's going to get denied. Then they can appeal and say, actually, what I really meant to say was, I'm scared for my safety. Or they can say, I actually didn't mean to ask for it, or whatever it is. But they have 90 days, like with most decisions at DSHS, for a fair hearing. And then DCS will wait that 90-day period to until they make a determination of what to do. CPs in some cases, if they're just like, oh, just get on with it, just go ahead and start working, they can file a written request and ask DCS to start working the case, and they will, but it has to be in writing. So medical assistance only. So this is like an ever-changing landscape that right now this is sort of our filler slide, which is historically you could get just medical only, and it was a very confusing process. Anyway, but I don't even need to talk about that because that's not the case. So right now, people who are getting medical only will get a letter saying that child support services are available, but it won't open a case. So the nice thing is that for people who don't know that there's Department of Child Support, they'll find that out. They could get connected, but they don't actually have to cooperate. We'll see what happens, with the Affordable Care Act, also known as Obamacare. There was a hope that medical would trigger a child support case, but just the way that we implemented it here in Washington, there was not a good cause option, so we did not do that.
So again, if you hear from people from other states, different states, each state implemented the Affordable Care Act the way they wanted to. The federal health benefit exchange does have good cause possibilities. So if a state just uses the federal exchange, they may open a case. And if you're someone who's worked in this field for more than, say, 5 years, you historically remember that just opening medical would get you a child support case. But right now, if all you get is medical assistance, you do not automatically get a case with DCS, although you could ask us and apply for services.
And this, this to our point earlier of the question of why is it an opt-in versus opt-out, this is, I think, a real win for victim advocates that our state really saw that, okay, this was a misstep, that we didn't include good cause, and so we're not going to make it a requirement because it's just too unsafe, even if it's unsafe for a small percentage of people. So I just appreciate that this was the position that the state took. So we'll see what happens. It could change, and we'll let you know. So childcare, similarly, there's been lots of different ways that we've done this, but currently there is not a requirement that if you get childcare help from the state that you'll open up a child support case. When that does get connected, there are good cause exemptions, but currently we don't have a requirement. So the pass-through, I mentioned this earlier, we had a pass-through between, in those 3 years, or 2.5 years really. And what was nice about it was that if you were getting child support and you were on TANF, if the state got more than $100 a month, if you had one kid, then you could get that pass through up to $100. So if you got, you had to actually get 100, right? They wouldn't pass through if you had less than 100.
No, what would happen was when a family was on TANF, we'd look at what child support came in, and it depended on the size of your assistance unit. So if the non-custodial parent paid $50 in the month, that would pass through to the family. If the non-custodial parent paid $200 a month, If you only had one child in your assistance unit, we'd pass through the first $100. If you had two or more children, we'd pass through the first $200 we collected. And what confused a lot of people is they wanted that pass through every month, but we couldn't pass through money if we didn't get a payment.
Right.
And so it all depended on what kind of payments came in, and up to $100 a month would go if you go through with one child in the AU, and up to $200 a month if you had more kids. And these numbers come from the federal law. And the rule is if we collect support while someone is on public assistance, the state and federal government get to share in whatever is kept. It's called retained support. And so what the federal government said, they wanted to encourage the states to pass through support, and they said, for these amounts, you don't have to pay us the federal share. So essentially what that meant was we would pass through up to $100, and the state would essentially give up $50, and the feds gave up $50 in the interest of getting that money to the family. And for the bigger families, the state gave up the 100 and the feds gave up their 100. And so that was sort of how they made it not be penalizing the state. And as the economy got worse in the state of Washington, the legislature looked at this and said, you know, we really can't afford this, because it was something like the state was foregoing collecting, I think, $3 million. I can't remember the exact numbers. And so the legislature said during the 2011 session, we can't afford this anymore. We realize it's good for families. And what was kind of funny is they wanted to stop it. They wanted to terminate it. And legal services, I don't know how many of you have heard of Robin Zukowski, who works for Columbia Legal Services, but she was very big voice in support of benefits for poor families. And she convinced them to say, we're suspending it instead of terminating it, just to, get it into their heads that it could come back. Mm-hmm. And for next year, there's a bill being proposed, an essential Let's Fight Poverty bill. And they're talking about bringing back the pass-through. And over the last couple of years, different legislators have proposed different bills bringing back the pass-through. The one thing that is not clear, I don't want you to get too excited that if the pass-through comes back, it's going to be in these amounts. Uh-huh. It could. The last suggestion I heard in the 2016 session was one senator was looking at $25 a month, up to $25. Another one was looking at up to $50. Another one wanted to go back to these numbers. So
stay tuned.
Yeah, it's possible. We're gonna talk about bringing the pass-through back. I have not heard anything definite on what the dollar amount will be, and until we know what the legislature passes, then we'll know the number. And you know what I know at this time.
And so I think that the key takeaway for this is that stay tuned. We'll update you in terms of the policy that's happening. But that this, I think, is an opportunity that if it comes back, it is a real advantage to having good cause level B rather than good cause level A if it's safe. Because then it enables you to get more, access to money. And I just think there's still something really powerful about having child support established while you're on assistance, so that when you go off, it continues and it can really help you out.
And one of the things that was discussed about, yes, it's good for the family to get the money passed through, but a lot of people who work with non-custodial parents think it's a very good way for the non-custodial parent to feel that he or she is really contributing to the family, because the first $100 that I pay when my child and its parent are on welfare is actual money I paid that's going to my family. So I am actually contributing to my family. Mm-hmm. And a lot of non-custodial parents over the years have it's a real hard time to say what I'm doing is helping reimburse the state for the TANF my kids are getting.
Yeah.
But this is my money is going through, and it's the non-custodial parents feel better.
So somebody has a question that says that they're confused about that, and their question is if the NCP makes a lot of money and the child support order is for $2,000, then would the custodial family on TANF only get $100? In that case, yes, but if somebody's child support order is for $2,000, then the best case would be to not be on TANF and actually just have the child support. That said, it's hard because sometimes the child support is inconsistent, and so people have to make the decision, do they want the consistent state amount even if it's less, but they know that they'll get it. So I think in rare cases that would happen, but I think in most cases if the child support order is that high, they probably wouldn't go on TANF.
And that can determine maybe mom went on TANF and then the court order or support order was entered later. And there's a rule in TANF right now that says the first month child support collected exceeds my grant amount, the state keeps the child support unless there's a pass-through and there's some money going through the family. Once you have 2 months in a row where current child support exceeds the grant amount, in the third month they're going to terminate your TANF grant because, number one, that way all the support paid goes to the family, and number two, you don't keep ticking away on the TANF time clock. And like Eileen said, this works best when we've got consistent payments. And I've seen some families where it's a higher than grant amount payment, and so they'll get off TANF, but then something happens and the child support doesn't come in. So mom may have to go back on TANF. But again, if we're getting consistent payments, the best interest of the family is getting off TANF and just getting that money coming to them.
So somebody asked a follow-up question, would you encourage the court to authorize the child support to be collected automatically so there isn't an issue with inconsistency?
Well, collecting automatic
Right.
is, so again, I'm a state employee. I'm an excellent person to set child support for because I'm salaried. I'm an excellent person to collect child support for because I work for an identifiable employer and I intend to work till I retire. And so that's me. Or I could be someone who works sporadically. I could be someone who gets jobs and then gets fired, or gets jobs and then quits, or works under the table. You know, so yeah, the ideal person to be a non-custodial parent is someone with steady income that's traceable so we can collect it. But we can't guarantee that out of every non-custodial parent. And just because you owe child support doesn't mean you're going to pay it. And I don't know if there's actually a state that does this, but a lot of people think that the role of the child support agency is to pay the child support to the family and then collect it from the non-custodial parent, but that's not how it works.
Mm-hmm.
You know, we collect it when we can, but there are a lot of non-custodial parents who evade our collection attempts.
So hopefully that answers those.
And if that wasn't a clear answer, you'll see my phone number later.
Right. Okay, we'll keep going, but these are great questions, and they're you know, they're ones that we've heard before in terms of just you're doing it right, everyone. Okay, hold on. I have one more follow-up here. I just want to make sure. Somebody's saying, isn't there a form you can sign to have the NCP have an account with DCS? So yeah, go ahead.
Again, the fact that the NCP is required to pay child support doesn't mean the NCP will pay child support. And so when you receive DCS services, you will get the opportunity to have either payments sent out to you by electronic funds transfer to a bank account or through the DCS card, which is a stored value Visa card. And the non-custodial parent can either, you know, if they're paying through wage withholding, then we're getting money, their employer takes it out of their check, they send it to us, we send it to the custodial parent. When a non-custodial parent does not have a traditional employment arrangement, some of them pay through the internet or through repetitive EFT. But they don't just say, DCS, here's a chunk of money, take my child support out of this. So unless they pay, we don't have anything to send to the custodial parent.
Okay, so I mentioned this earlier. It says debt may accrue while good cause level A has been granted. So this is just something of a heads up. And this is again why if you can stop I guess the case is opened, but from action being taken on the case by applying upon application for good cause, then this helps a lot with this issue. But that if a child support order has already been established, then the debt accrues even if the Division of Child Support is not working the case. So, and then I think you mentioned this earlier, the last bullet point that somebody can.
Because a lot of, every now and then someone asks me, oh, so all I have to do to avoid paying child support is beat the crap out of my spouse. And the answer is no. That, there's a question of, am I enforcing your order doesn't really impact whether you owe support for that period. And when we're talking good cause for a family on TANF, we're talking whether the Division of Child Support is working the case. And so it's not you get a free ride as a non-custodial parent. It's just for a time period, which is the good cause period. We are not working the case, so we are not collecting on an existing order, and we're not seeking to establish an order. But that doesn't mean there is no child support obligation. Because if you have a child, you have an obligation to support it.
Right. Okay, so in terms of other protections, so good cause level A and B come with their own protections, but then there's also just protections built into the system, which is the confidentiality requirement. So I just gave you these RCWs and WACs just so that you can have them if you're having an issue, and some people like this kind of thing. Nancy likes to rattle off all the numbers.
It's my life.
It's her superpower. But, so there's confidentiality requirements. There's also special steps that DCS has to take when addresses are requested, and so that's in the second bullet point. And then there's this automatic denial, and I love that it's actually written into a warning to the custodial parent when DCS finds out that there's reason to believe that a release of the address may result in harm. And then there's another protection that survivors or NCPs can ask DCS for notice before their address is released. So if they don't have the protections, they can actually ask DCS to flag it, and they will do that, and that's detailed in the last.
So under current law, the notice and hearing protection only applies when the non-custodial parent asks for the custodial parent's address. If the custodial parent asks for the non-custodial parent's address, we do make them use a special form, but we don't notify the non-custodial parent and give the non-custodial parent either a chance to object to release, and we don't tell the non-custodial parent their address has been asked for. But sometimes your survivor is going to be the non-custodial parent. And in that case, the survivor can ask DCS and say, don't release my address unless you give me notice. And so then, let's say for some reason the perpetrator ends up the one with the kids, and there's an order saying the survivor has to pay child support to the perpetrator. Our case will set up the survivor as the non-custodial parent. The survivor can contact DCS and say, please don't give my address out to the other parent. And you don't even have to tell us why, but if you say because of violence reasons, then I'll do two things. I will set the family violence indicator on your case, which we'll talk about a little more, and your case will qualify for notice before we release your address. And so it's important to know for when the survivor is the non-custodial parent.
We had a different question that was about, have you ever seen a court impose jail time on the NCP for not making child support payments as ordered?
Many, many years ago, when I was an attorney in private practice, I would occasionally see someone jailed for contempt of court when they did not pay their child support. The court has the power to do that. What I've seen more lately is the court will say, non-custodial parent, you're going to go to jail unless you pay. And so I find you in contempt, non-custodial parent, and here's how you purge your contempt. Pay this much amount of money every month, and you can stay out of jail. And the courts sort of look at it as, if we put this person in jail, they're not going to be working, so they won't have money to pay. And I can't be held in contempt if I really don't have the ability to pay. So it's a funny mix-up. But if I'm the non-custodial parent and I have the money and I have the ability to pay, the court does have the power to put me in jail until I pay.
When does wage garnishment happen?
Wage garnishment happens as soon as we get your case, usually, because again, like I said, the law requires that all orders be made payable to the WSCR. The law also requires that all orders be subject to wage withholding unless the ALJ or the court is convinced by the parties that there should be another arrangement. So most child support orders will say payable to the registry and subject to immediate wage withholding and without prior notice. So again, if that's my child support order and it comes into the Division of Child Support, automatically a payroll withhold is going to go to the state of Washington because you know where I work. But even if the order says immediate wage withholding is allowable, if I don't know where the non-custodial parent works, I have to figure out where to withhold from. And so I may not get it right away, but I'll be working on it. And the chances are, if we have an employer, we will have a wage withhold.
Great. So just one other address protection to know about. You can ask, so, and I was thinking that this also is sort of relevant for like the wage withholding, that when it's less likely to happen is when somebody's like self-employed, or they're sort of, I think you gave the example once of it's Joe's Pizza and they're Joe, or Joe's their best friend, or, somehow there's something going on. And so for folks who are worried about their insurance, their address getting out because of the insurance, the DCS will enable you to use their headquartering mailing address on any of those forms about health insurance. So that's just a helpful thing. That said, that doesn't prevent the health insurance company from actually sending the person who's paying, so in most cases the non-custodial parent, the statement of benefits, all of that other stuff. And so, their confidentiality practices vary widely, and we just don't have the same protections for them. So it's just something to think about, that if somebody's concerned about if they really are trying to keep their address confidential and location confidential, that health insurance, there's a lot of info that gets sent out. I just think about folks who have, monthly allergy shots. That, is a real obvious way. You see a pattern, like if they're being stalked, that's a way that they could easily figure out when, your son has an appointment. So those kinds of things. Or it could also, if it shows mental health counseling, somebody, that's often a way that then somebody, inserts themselves and says, well, why are they having to get mental health treatment? What's wrong with you? You're not a good mother, that kind of thing. So those are just things to think about as an advocate, to sort of bring up as well. Okay, so somebody's just asking, what does the process of withdrawing good cause look like? If a person files for child support order through the court, what happens if there is already a good cause finding through DCS?
Okay, let's assume that the survivor claimed good cause not to cooperate with DCS in the initial application for TANF. And again, like Eileen said, we've evolved over the years, that it used to just be that I would apply for TANF and say, I think it would be too dangerous because my non-custodial parent has threatened me that he'll kill me if I get child support, whatever. And so we leave it up to the survivor to work with the people in Community Services Division, that here are my concerns, and knowing what I know about my particular perpetrator, do I think it's safe for child support to go ahead, in which case level B might be more appropriate, or do I think my perpetrator just is going to go ballistic, so I need level A? As time goes on, as my perpetrator perhaps matures, goes through treatment, whatever, maybe I decide that I think it's safe now for child support to proceed. So I could either change my good cause level A to good cause level B, or I could say, I don't know, he found Jesus, he's a different man, he's perfect. So I think it's safe to just have no good cause. And then we could start working the case. Or even, so that would mean DCS wouldn't work the case. But then something happened, according to this question, and the parties went to court. And when a case has been closed for good cause level A, even if the family is on TANF and the non-custodial parent brings a court action, we don't work the case because we have said too dangerous for us to get involved. So what I'm assuming out of this case, or out of this question, is that somehow the survivor participated in the court process. And so then if we would get a court order in, we would look at it and say, well, we still have closed for good cause level A. Does this mean that our survivor is applying for services? And so, it all depends on the facts of the case. If you look at a court order for child support, there is on the very last page where the parties sign and the judge signs, there is a space that says, I am the custodial parent and I hereby apply for Division of Child Support Services. And if the custodial parent signs on there, and it's a it's a non-assistance case now because there's no TANF, we will read that as an application for services, which is what it is, from the custodial parent. And so it will open a case. If she's still on welfare when she applies for services, then we will ask CSD to contact her and say, wait a minute, you're on welfare with good cause and you've just applied for services, what's going on? But if there's no welfare, chances are we're going to look at that as a non-assistance application.
And just a reminder, then, if there's a withdrawal with assistance, then remember that DCS waits 90 days to make sure that it was an intentional withdrawal and that it wasn't a miscoding or anything like that. Okay, moving on. We are getting short on time, so I want to make sure we get to everything. So this is exciting. For years we have been, this has been the most ridiculous slide ever, but it has an update, which
maybe not the best way, but at least we know now.
Yeah, so go ahead.
Because of federal requirements in 2015, every state adopted the Uniform Interstate Family Support Act as it existed at the 2008 version. And UIFSA deals with how do I work a child support case when one parent lives here and the other one lives in another state, on a tribal reservation, or in another country. And there are all these rules about what kind of information, if I am sending a case to another jurisdiction, another state, a tribe, or another country, what kind of stuff do I send them? And now the law says I have to give them the address of the custodial parent. So before the Division of Child Support refers a case to another jurisdiction, we will send a notice. We've traditionally done this. We send a notice to the custodial parent saying, we have to refer your case to New Jersey or France or whatever. And we have to give them your address. Do you have concerns about your address information being released? And if you do, you request a conference board from DCS and to get a non-disclosure finding. And so once we've determined that your address should not be disclosed, we still have to give your address to the other jurisdiction, but we send it with a warning saying, you cannot disclose this. You need to keep this information under seal and not give it to the non-custodial parent. We used to be able to say, dear other state, please open this case and use the WSCADV address for the custodial parent because it's too dangerous to give you her address. But we no longer have that option. So all we can do is send your address with a non-disclosure finding.
So it's clearer, but it's not as
It's
good.
clear. It's not fabulous, but
yeah,
that's what it is.
Okay, I think we're pretty close. I just want to check in with folks if there's any terminology that we've been using that you know want clarification on. This is just a reminder for folks maybe who came in late that there are 2 handouts that are attached, one of which is the Terminology Stew handout. It's a front and back one-pager, and then the other one is the actual PowerPoint from today. So if you haven't seen those are handouts that are attached that I encourage you and welcome you to download and keep for your own uses. Okay, so any other questions or comments? I know this is a lot of information, but in my experience, I really have to be the piece that you happen to know about and help them, especially sending folks there before immediately can just be so handy.
And one in every community service, which means that as advocates, you have a resource, and the survivors would.
And for folks who aren't quite familiar with, I know we've been talking a lot about TANF trainings, webinars, and in-person things at our conference often.
We look forward to seeing you guys and talking every conference.
Yes, so great time. It's also a really great opportunity to volunteer and connect with other folks in your community who might want to come as a team, so I encourage you to do that. Our conference this year is in Linwood, so on the west side of the state. Just a lot of the Tommaso will be leading in, our new policy coordinator. I encourage you to tune into that. You can find the details for that under that link for webinars. Nancy has graciously provided us and you with her contact info. She really does actually answer the phone when you call her, if she's there, and her email. And she's just a wealth of information, and I've always found that if I have a question that she doesn't know the answer to, she will find somebody who does. So just a great place to start. And
don't worry, oh, she's in headquarters, I don't want to bother her. I feel this is a big part of my job, so I'm always happy to talk to people. But on the next page is a list of people that we have in our field offices. And so you see their offices and their contact information. And these are people, no one was voluntold, as the term is.
Right.
These are all people who volunteered to do this. These are all people who have a real interest in domestic violence and how it impacts child support cases. I will give a shout out to Jim Ward in Olympia. If you have any questions, especially about military people, Jim is retired military and knows a heck of a lot. So he's a good resource if you've got that connection. And just anybody else, all of these people are really informed on both DCS and domestic violence issues, so they would be great to call.
Yeah, I can't speak to how great they are enough. I mean, they're some of my favorite people in the state of Washington. They really are unbelievably committed to this issue. They all volunteer to, hear more about domestic violence that is only tangentially, to be totally honest, related to their job, but they're very committed and connected. So they're super helpful if you need local folks. So I think, whoops, that might be it. So I realize my contact info is not on here, but hopefully you know how to get in touch with me. But I will, my email is just Eileen, I-L-E-N-E, at our acronym WSCADV, WSCADV.org. And you can always also find me on the WSCADV website. That might be the easiest way. So I'm going to pause one more moment to see if anybody has any final questions. And while I'm pausing, I just want to say I so appreciate the work that you do. I know that you all have a lot on your plate, and you just are really all doing incredible advocacy. Whenever I talk about this issue, I really feel connected to the state of Washington because we are doing better work, quite honestly, than other states, and I also feel like that is the same for our advocacy services. So I just want to acknowledge all of you out there and appreciate you, and I hope that you all get to enjoy the sun. At least it's sunny here. I'm going to check one more. Somebody said thank you, and I think that's it.
Okay. And here's just one thing. It's not a legislative update. It's sort of a court update. This summer, you are going to see new court forms used in the superior courts, especially with family law. There's a project that was led by the Access to Justice Board in the state of Washington, plain language legal forms. And they will be available for use starting May 1st. They will be mandatory starting July 1. And if you want to get a look at them, you can go to the website for the Washington courts, which is courts.wa.gov, so courts.wa.gov, and go to court forms. And there's the plain language forms. I was involved in the process. It was many years of work, and I'm not going to say they're perfect, but I think they are a lot more user-friendly, and they look differently, but they do essentially the same thing the old forms did, but I'm really hoping they'll be easier to use and easier to understand. So if you are dealing with survivors who bring you paperwork to look at, just be aware there's going to be new forms.
Great. Okay, everyone. Well, it was delightful to see you virtually. I hope to get the chance to see you in person for real sometime soon. And honestly, I would love to see you at the Refuse to Abuse 5K, but I'll also take seeing you at the conference.
I have talked to so many people who went to the Refuse to Abuse either to participate or to volunteer, and they said it was just fabulous.
Yeah. It's really good energy, which is nice. We need that. So, all right, y'all. Well, happy sunny day, and look forward to connecting with you again soon. Take care, everybody. Bye.
Bye-bye.